couple of points I want to make. Number one, the effort to get universal injunctions has been pursued by litigants, including some of the attorney generals who serve on this committee. I know you did, as Attorney General, got several sought several universal injunctions.
Since you referenced the vast censorship enterprise of the Biden administration that a court declared was perhaps the biggest offense to the First Amendment in the history of the country, where there were named parties that were specifically enjoined, you mean that case?
Yeah, I do. My point here is that if there's an opportunity out there for a litigant, whether it's a lawyer trying to get the judge that he or she thinks is going to be the most favorable, or an attorney general trying to get the most relief for something that he or she believes in, they'll do it. So it's up to us if we think that process should be adjusted to change it. But it's not a Republican-Democratic deal. I mean, it's what litigants do. The second thing is, Professor Blackman, you mentioned how some of these universal injunctions inhibit the authority of the executive, right? What's the problem with that? I mean, what's so great about the executive having unlimited authority?
Well, I'll take the Alien Enemies Act in particular. This is a statute that's been around for 200 years. It's been enforced in various times. And historically, it's been a very deferential statute. The courts haven't scrutinized when it should be enforced, and they haven't told plaintiffs to turn around. So I think we're seeing not only aggressive use of the universal injunction, but also intrusions upon the executive authority.
So I get that. And let me just be clear. I disagree with you. And I disagree with the executive invoking what I regard as a very discredited law and using it to deny due process. So I'm on the side of pushing back against executive authority. So I don't see that as a big problem. Professor Shaw, one of the things people here are talking about is the class action. Mm-hmm. And here's my question with it, and I want you to address this. I had a small town law firm, and I'd have people who walk in, and every once in a while, they had a hopeless case that we'd take, and we'd get them relief. And if I had to do that in a 4-person law firm and certify a class action, I couldn't have taken that case. So this so-called remedy of using the class action means that those Vermonters or those folks in Washington State or wherever who go into a lawyer's office to seek relief, and that lawyer's willing to take the case, what are the burdens on that law firm if they have to certify it as a class?
Yeah, I mean, it seems to me that, let's take maybe the birthright citizenship example, arguments that challenges can be maintained against this executive order, but they have to be done using the class action device. I'm not sure if those are being made in good faith. Rule 23 of the Federal Rules of Civil Procedure has relatively demanding requirements. The Supreme Court has ratcheted up those requirements in a series of cases in the 2010s. The plaintiffs have to be similarly situated in terms of their injury and the kinds of relief that they are seeking. And the Solicitor General in the Supreme Court a couple of weeks ago didn't disclaim the likelihood that they would be back before the Supreme Court saying, well, you shouldn't even be able to certify a class with respect to this executive order. So it feels to me like a little bit of a heads we win, tails you lose. You can try a class action and we will marshal different kinds of arguments against you doing that. But it is not as though it is very easy to satisfy the requirements of Rule 23. And I think that shifting from these injunctions to a pure Rule 23-based regime would disadvantage those unable to secure representation, who don't satisfy the requirements of class membership, and would mean no relief from government unlawful conduct.
Yeah. And that's one of the things that's so important, hopefully to all of us, is access to the courts for an everyday person in Missouri or Texas or whatever. So you get some lawyers who are just willing to do it because it's a neighbor, it's a friend, it's a cause they believe in. I want them to be able to act and bring that case to court and not have to go through the incredible expense. On the question of universal injunctions, I mean, are there some suggestions you have or forum shopping that you have that would expedite or address what you perceive to be some legitimate problems that aren't siding with the partisan divide on this question?
Yeah. Thank you for that question, Senator. I do think that single judge divisions, which allow plaintiffs to, with absolute certainty, ensure that they will receive a particular judge when they file in a particular division of a district, are an enormous problem, right? That forum shopping is not exclusive to these single judge divisions, but it is the most serious kind of forum shopping. And I should say, as of, I think right now, none of the orders against the Trump administration have issued from judges who sit in single judge divisions, unlike some of the orders issued against the Biden administration. But I do think that the Judicial Conference has already endorsed a proposal that would essentially eliminate these single judge divisions. I think that's something that we should all be able to get behind.
Thanks. Well, I'd be willing to work with my colleagues on some of these practical questions and practical answers where we strip out whether we agree or disagree with the particular decision that's been made by the court. Thank you. Thank you all.